Hello, this is a brief primer on the compliance requirements under the law against sexual harassment in India. The Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Act and the Rules 2013 mandates every employer to provide a safe working environment at the workplace, which shall include safety from the persons coming into contact at the workplace. Where the employer fails to comply with the provisions of the law, there could be penalties. For a first conviction, the employer is liable to be punished with a fine of up to Rs 50,000. For a subsequent offence, the employer is liable to twice the punishment which might have been imposed on the first conviction and or cancellation of business, trade license or registration. Hence, it is important to maintain documentation to show proof of compliance. What all does the law prescribes? Employer has to formulate a policy and cascade it to all the employees at the workplace. An internal committee has to be constituted with at least 4 members, including an external member. Senior woman employee has to be the presiding officer and 1/2 of the total members have to be women. There should be a mechanism to ensure assistance to the complainant if they wish to file a complaint with the police. Awareness programs have to be organized by the employer at various levels. The internal committee members have to be trained to inquire into the complaints in an effective manner. The internal committee is vested with the limited powers of a civil court. Only the internal committee has the jurisdiction to redress complaints of sexual harassment and submit the recommendations to the employer. SASHA designs trainings for internal committee members to take them through the process of inquiry not only from a legal perspective but also from a practical perspective, as they may have to wear several hats in their roles. People leaders are the key stakeholders in the effective implementation of this law. Many a times, grievances are reported either to HR or the managers. Therefore, it is important to conduct awareness sessions so that they have clarity on the due diligence that is expected from them. In addition, management trainings are designed for employees. Employers recommended for MDs, CEOs, board of directors and other decision makers, including HR heads and legal counsels. Regular training and awareness programs have to be conducted for all the employees. Sessions for employees, staff members is designed as an interactive session to educate and empower employees about their rights as well as duties under the law against sexual harassment. Notices have to be displayed at conspicuous locations at all notice boards. The internal committee has to submit annual report to the district officer and the employer. Employer should include the details in the annual report of the organization. Annual report should contain number of complaints of sexual harassment received in an year, number of complaints disposed of during the year, number of complaints that are pending for more than 90 days, number of workshops or awareness programs against sexual harassment carried out, and the nature of actions taken by the employer. To summarize, it is the duty of the employer to ensure compliance. As an external member, SASHA will guide in effective implementation at each and every step. The objective is to ensure a safe and inclusive working environment for all the employees at the workplace. Thank you.